Make Your Case video by Philadelphia Legal Assistance. This video will give you tips on preparing for a child support conference. Every child support case follows the same steps. You must first file for support by filing what's called a complaint for support. Then, the court will schedule a court date called a conference. At this conference, a court official called a conference officer will review the income and child-related expenses of each parent and calculate a proposed amount of support. The conference officer decides who should pay support and how much by following guidelines set by the law. First, he or she adds up the income of both parents to get one total family income. A parent's income is all money the parent gets, apart from SSI and welfare. This includes bonuses, commissions, lottery winnings, under-the-table wages, and money recovered through lawsuits. Pretty much everything counts as income. Next, the conference officer consults Pennsylvania's child support guidelines to figure out how much support a child is entitled to each month, given the combined income of the parents. A non-custodial parent will be expected to pay a part of that amount to the person who has the child living with them. For example, if the non-custodial parent earns half the total income, he or she pays half the guidelines amount in each child support month. If they earn a quarter of the total income, then they pay a quarter of the guidelines amount. If they earn all the income, they pay the full amount, and so on. The conference officer will do this calculation, and if everyone agrees to the amount determined by the conference officer, the case will settle right then and there. If the parents do not agree, there will be a hearing at a later date with the support master, where you will have to present evidence, including testimony, about anything that is disputed. Over 90% of parties in child support court appear without lawyers. This means it's up to you to know what to ask for and what to expect. There are some common myths about child support that often prevent parents from reaching agreements at the conference. The first common problem comes when parents ask for a hearing with a support master because they think the guideline support calculation will leave them with too little income to support themselves. Generally, if you object to the calculation at a conference simply because you think it's too much or too little, and not because the conference officer made some mistake, you're not going to get a different result. The amount of a parent's child support obligation will not be so large that the parent cannot support himself or herself. There is an amount of income called a self-support reserve, which is a portion of a parent's income that the state will always let parents keep to support themselves. This is often important when people have to pay child support for multiple families. If paying child support for an additional child would take away more than half of a parent's income or put the parent's income below the self-support reserve, the court will reduce all of the parent's support orders so that the parent has enough income to live on. Hearing this, some parents think, okay, I'll just make less money so I owe less support. However, parents cannot voluntarily reduce their income in order to lower a child support obligation. If a parent could be making more money than he or she is, the court will do the calculation using the parent's earning capacity instead of the parent's actual income. The earning capacity is how much the parent is capable of earning, whether or not they are earning it. Another area of confusion is the relationship between child support and child custody. Generally, support and custody are totally separate. A parent will not gain custody of their child just because they pay support. Nor will a parent be denied custody simply because of his or her failure to pay support. You don't need to have a custody order to file for support and start receiving support. You just have to have the child living with you. When a parent has shared physical custody and has the child about 50% of the time, it is often the case, but not always, that the parent no longer has to pay support. Because of this, sometimes parents think, I'll just file for 50-50 custody, and then I can stop paying child support. Nevertheless, custody judges will sense when a parent's custody filing is motivated by a desire to cease paying support, so this tactic won't work. Now that we've talked about the relationship between support and custody, let's talk about the relationship between support and welfare. If a custodial parent or caretaker gets cash assistance from the Department of Welfare, welfare will file for support against the non-custodial parent. The idea is that welfare shouldn't be picking up the slack when a parent fails to support his or her child. The custodial parent does not get a choice in the matter. Welfare will file for support regardless of what the parent wants. The only exception is for domestic violence survivors, who believe welfare's filing for support would put them or the children at risk. Under that circumstance only, a parent can ask that welfare not file for support against the other parent. Some parents think that if welfare files for support, the custodial parent gets the cash assistance and the support payments. This is not accurate. The support payments will go to welfare, although the caregiver might get some of it in the form of small pass-through payments. These child support basics should inform the decisions you make about your case, including whether or not you want to settle at a conference. If you don't make an agreement at the conference, you'll go to a hearing with the support master. The support master is going to look at your income and expenses and do the same calculation as the conference officer. If you're still not able to agree, you'll have to show evidence as to why the guideline amount is wrong. For example, if the calculation failed to include childcare costs, you would want to present evidence of those expenses and argue why they should be covered. If the problem is that the other side says they make less money than they actually do, or says they're not working when you know they are, you'll want to show that they're not telling the truth. For example, you can ask if they have a cell phone, a car, or an apartment where they pay rent, and how much they have to pay for those things. Often, these expenses will be more than they say they make in a month. You can also present evidence such as photos of him or her in a work uniform, or a text message or post on social media complaining about work. If the other side says they are looking for a job but can't find work, remind the support master that if a person isn't working but could be, the court can order them to pay child support based on their earning capacity. To show the court that the person has earning capacity, ask questions like, when were they last employed? How much did they earn? Whether they graduated from high school or college, or if they're in good health and able to work, and so on. You want to show that the person could be working, but isn't putting in the effort. The child support process can be stressful, but armed with knowledge and realistic expectations, you'll be able to act as your own advocate and get satisfactory results.